This is Fred Wahl, the Visa Coach. Today's topic is ICE detains K1 visa holder for overstay. Now, I have bad news about one of my clients. She overstayed her 90-day allowed fiancé visa stay by 3 weeks, and she is now in an ICE detention center awaiting possible deportation. It's a sad story and a warning for those who may be delaying sending in their formal applications for adjustment of status in order to get the green card for their lawful permanent residence. I am Fred Wahl, the Visa Coach, and I personally work with you, preparing for you the forms and documents needed to bring your loved ones home to the USA. And unlike those common, second-rate services that abandon you once your application has been submitted, I remain with you providing support throughout this complicated immigration journey. And please watch to the end, because towards the end of this video, I suggest what you can do to avoid a similar fate for your loved one. Now let's talk about the situation that ICE has detained a VisaCoach K1 visa client. U.S. Immigration and Customs Enforcement, ICE, has just detained one of VisaCoach's, my K1 Fiancee Visa clients. She is currently being held at a Texas detention center facing deportation. She married her American fiancé on time, within 90 days of arrival. They had started to work with VisaCoach on their adjustment of status application. Unfortunately, the couple had some, domestic drama. She moved out, and she was living at a women's shelter. Someone, we suppose a member of staff at the shelter, got a hold of her passport and noticed that she had barely overstayed her visa, and then they called and reported her to ICE. She had been in the USA for just about 110 days, so she had overstayed her visa by only 3 weeks. We have helped other clients who had overstayed for years without any fuss. And under normal circumstances, ICE would have ignored this as being too trivial an issue. They really do have much bigger fish to fry, with millions of undocumented aliens who illegally entered the USA. But this time, ICE took action. They came to the shelter in force and picked her up. And now she is in a cage in a detention center on the border with Mexico. Her husband, they have fortunately reconciled, is desperately trying to keep her in the United States. Now it's a race between adjusting her status to a lawful resident or deportation. Now, we rushed to complete and submit her adjustment of status application. The couple's attorney, remember, I'm not an attorney, the couple's attorney advised that when she comes before an immigration judge for her coming deportation hearing, that if she can show proof that she was married to a U.S. citizen and that an AOS petition had been filed, this might sway the judge to deny the deportation order and may even release her from custody. But it may be a close race, even though USCIS has by now received her AOS petition, because it is usually a few weeks and sometimes months before USCIS confirms that the application is in process by issuing a receipt to the applicant. Now, once adjustment of status case is in process, her immigration status changes from overstayed to pending. And under normal circumstances, when an alien's immigration status is pending, they can lawfully remain in the USA while the case is being adjudicated. Now, we hope that ICE does not push the case and deport her before evidence of the USCIS receipt can be presented. ICE appears to be responding to pressure from the Trump administration, working to detain and deport as many as they can, as quickly as they can. And this action probably is taken in order to provide headcount statistics to show Trump's campaign promises on immigration are being kept for the nightly news. We don't know what is going to happen in this case. We hope things will work out, that the gal and her spouse will be reunited on this side of the wire. Maybe in a month or two, we will have an answer. In the meantime, what should you do? Okay? Well, normally, in the past, frankly, my opinion, USCIS couldn't care less if a K1 visa traveler overstayed, as long as they eventually filed the adjustment of status application. Routinely, my clients could be comfortable to hold off submitting their applications as late as 5 months after the 90-day expiry date of the allowed stay. Normal practice was that to submit within, this is going to be 240 days of arrival, would not cause any issues at all. Although many of my clients have actually waited longer, waited years, but also with no fuss. But now, no longer is delay an option. Based on this recent experience, best practice is that you, my clients, should apply much earlier and apply as close to the 90-day allowed stay as possible, ideally within the 90-day stay. And of course, before submitting, the foreign K1 visa holder should stay close to home. Don't go walkabout. Don't create an opportunity for some, evil person to report an overstay to ICE. Now, under the current Trump administration, a revised version of the I-485 form was issued. A new question has been added, which is, have you ever been unlawfully present in the United States? This means that even if an overstay was a single day, the applicant must now report it and bring it to USCIS's attention. The form is new, and I don't have too many clients that overstayed. However, I worry that one day USCIS may start making trouble for those who did overstay before submitting their applications for lawful permanent residency. The latest I-485 now has their signed confession that they overstayed. And what USCIS may do with this is unknown, but it is certainly a concern. Now, my advice going forward is you should marry as soon after arrival on the K1 Fiancee Visa as you can. Then complete and submit your application for adjustment of status within the 90 days of allowed stay. Now, if you must overstay, minimize the time that you are out of status. Now, of course, VisaCoach is available to help you prepare a strong and well-documented AOS application. But remember, it takes time to do things correctly. It takes time to generate valid, strong evidence and to document it. When a K1 client returns and hires us for adjustment of status, we know them pretty well. So we immediately kick the process off by posting at their online portal a detailed evidence checklist on what is needed for AOS. So on the same day you hire VisaCoach, you'll get your detailed guidance and can get a running start working on the evidence that is needed. Okay? You can then take your time to fill out our questionnaires, which we also send you the same day, with updated background details, but you can send them to us later. We already give you the evidence checklist. The sooner we start, the sooner we can submit the application while still having enough time to do it right. Well, anyway, the sooner we start, then, and the earlier we start, we have a good chance of doing it right properly. If I have news on developments of my client who is in detention or learn of other issues with overstays and or new issues with adjustment of status, I will be sure, excuse my voice, to report on them. This was Fred Wahl, the VisaCoach. I am here to personally guide you on this journey. Now please like or add your comments to this video. Click here to sign up for our monthly newsletter and receive bonus ebooks. Here for YouTube's recommendations. Here for a playlist of recent videos on adjustment of status. And here to subscribe to our channel.